We're here on a review of the trial court's order certifying the class, and of course, as this court well knows, the standard of review is abuse of discretion, meaning that the trial court order was either fanciful or arbitrary, or that no reasonable person would do what the trial court did. Judge Padovano, to your point, this appeal is unusual in the sense that if you look at their brief, every one of their arguments, standing, commonality, typicality, predominance, all of them ultimately get back to the same point, which is their argument that in the end, we will prevail, we believe, on the statute of limitations. And consequently, no one has a claim here, not Ms. Conlon, not any class member, and consequently, none of the elements of Rule 1.220 can be met. But that requires, to do that, for a determination, for you to make a determination on the merits of their statute of limitations affirmative defense and decide class certification on that basis.
But counsel, isn't there several cases? There are several cases that say if the claim of the sole class representative is time barred, he or she may not serve as the class representative, and class certification is improper in that case.
There are cases that say that, Your Honor, but you're going to have to make a determination then that their statute of limitations affirmative defense is correct in order to reach that result.
And isn't that a de novo determination?
No, not on this record, because the issue, the Supreme Court said in Sosa that the issue for class certification standing is not to go to the merits, but to look at whether the class representative has alleged a justiciable case in controversy. The evidence in this record is that Ms. Conlon paid a fee, that the city, and she challenges the lawfulness of the fee, that the city has refused to refund it, and the city continues to collect the fees, meaning she's still subject to paying further fees. And the argument that's being made here by the appellant could have been made in the Higgins case, Judge Padovano. If in that case, the Commonwealth Land Title case versus Higgins, the appellant there was saying the same thing that this appellant is saying, which is we believe that in the end, our view of Florida law will be correct. And if our view of Florida law is correct, then the title insurer had no obligation to disclose the policy terms. And if we're correct on that, then ultimately the question is going to be whether every individual agent made a disclosure. And that would throw us into all individual inquiries. And this court in the Higgins case said, well, that is a determination on the merits. Ultimately, for the trial court, once it's presented, it's not an issue that is appropriate on class certification. And the court, the panel in the Higgins case, affirmed the certification of class. But you could have made the same argument that they're making here today in Higgins. You could have said in Higgins, well, if we're right on the law, and they say they're right on the statute of limitations, Higgins could have said, if we're right on the law, then the class representative has no claim, no standing.
But, counsel, let's assume we agree with that. Isn't there a typicality argument with the representation of individuals within the class whose payment goes back beyond 4 years? So if the issue is date of payment, are those people properly defined in the class?
Well, we believe they are, Judge. Remember, there's one ordinance and there's one methodology under the ordinance to calculate the fees. Every class member paid a fee calculated in the same way. It was all done just according to a uniform mathematical formula, so there's no difference there. Ms. Conlon paid one fee, a fee according to that formula. The only issue that would be different as to the people who paid it before August 2007 is the response to the affirmative defense, not to their claim, but their response to the affirmative defense, because those people would then be relying on the doctrine of equitable estoppel. That's the only difference. It's no difference in the claim, Your Honor. It's a difference in the response to the affirmative defense.
And it's your position that because of the nature of the affirmative defense, that's not appropriate for consideration now?
Yes, sir. Well, and as I think you pointed out, Judge Padovano, they moved for summary judgment on that affirmative defense. And the trial court found there were genuine issues of material fact on this record and denied their motion for summary judgment. And essentially what they're seeking here is the very thing you pointed out, which is, backdoor review of the trial court's denial of their motion for summary judgment. And Judge Rowe, to your question, are there cases that would commence the accrual of the statute of limitations upon payment of the fee? There are. We would point you to the Tyrell case, Spring Lake Development versus Tyrell. That was a maintenance fee. And the court there, actually it's a class action, the court there held that those who had paid the fee within 4 years of filing the suit, their claims survived. The ordinance had been passed years before, but they hadn't been assessed the fee until at the time they paid it. The court allowed the claim of those to go forward who were within 4 years, but they didn't assert equitable estoppel as to anyone earlier. So I commend Tyrell to you, and I commend the VES case to you. It was the same result in that case. And, we are not, Judge Rowe, this was another question you asked, we are not challenging this ordinance on its face. This is an as-applied challenge. The ordinance is not unlawful on its face. We're not saying it's unlawful. That's the very problem. The problem is the ordinance is misleading on its face. If they had done what the ordinance said, that is, collected the fee and spent it for improvements on the water system, that could very well have been lawful. The evidence before the trial court was that they didn't do that. They spent it for debt. They didn't spend it to expand or improve the water system, which is what they must do to comply with the Supreme Court's cases, Dunedin and St. Johns County. More to the point, Judge Rowe, the evidence also showed that they knew that the way they calculated the fee didn't comport with standard impact fee methodology. And there was an email to the city attorney on the eve of their adoption of the ordinance, which said, it goes through and makes that point, and then at the very end it says, in order to avoid opening the ordinance up to scrutiny of the calculation methodology, the ordinance should simply state the fee and how it applied. That was the evidence before the trial court. And on that basis, he concluded that there was an ordinance that was misleading on its face and that it was concealed. And there was no evidence presented that anyone outside of state or city government knew that. No evidence.
But just to clarify, you're not arguing then that when I first heard the as-applied argument, I thought it meant as applied to individual class members. You're not talking about that at all, are you?
Correct.
Because according to your view of the case, this applied exactly the same way to all of the class members.
Absolutely.
When you say as applied, you're talking really as enforced.
Yes.
Really is what you're talking about.
Yes, sir, as enforced.
Right.
And some of the cases use as enforced, as applied. I think we may have used as applied in our brief, but that's the correct characterization of it, Judge. And, Judge Rowe, I would say also, your question about aren't there differences between individual payers and developers, well, there's no evidence of that in the record at this point. That is wholly an argument of counsel based on what they believe the record will show later on. But the trial judge made his decision to certify this class on the evidence that was presented. And there was no evidence that was presented that there would be any differences between someone who paid a residential fee versus a commercial fee, because they're all calculated under the same ordinance in the same way.
And I think the difference I was suggesting was that a developer might pay that same fee multiple times on multiple pieces of property versus the individual property owner.
You're correct. But some homeowners did that too. If you have, the way the ordinance reads, if you have a home and you pay a fee when you got a building permit, and then if you add a garage apartment and you require another meter for that, you pay another fee. So there are homeowners who paid additional fees as well. But most importantly, on the issue of estoppel, which again goes to the merits of their affirmative defense, but we're talking about it, the evidence is that no one outside of city government knew that these impact fees were calculated in a way that didn't comply with the Constitution. And that's our position, that fundamentally it doesn't comply with the Constitution. And so we are taking the position that on this record, and I think the record supports it, that on this record, the fees are unlawful, because the Supreme Court in the Dunedin case said for an impact fee to be lawful, it must be used to improve or expand a utility for additional growth. There's no dispute in this record that those fees were not used for that purpose. They were used solely to pay debt for the acquisition of the water utility. So on the record before the trial court, the fees are unlawful.
So that's the issue. Those are the facts that are really relevant to class certification. The issues concerning statute of limitations and equitable estoppel are for another day.
Absolutely, Judge. What the record shows, the record before the trial court on class certification shows there was a single ordinance, 340 people or entities paid it. It was calculated according to a uniform mathematical formula for all payers. The challenge of all class members is the same. It's identical. That is, that the fees don't comply with the dual rational nexus test. Ms. Conlon paid a fee. She paid it according to the formula. She paid it in 2009, so she's within the group that paid within 4 years of the filing of the suit. The city presented no evidence, none, of any inconsistencies between Ms. Conlon's claim and any other class member. There was no evidence presented of any antagonistic character to Ms. Conlon's claim to any other class member. The evidence showed that most of the fees paid were in the several $1,000s range, many of them below $2,000. And on that basis, the trial judge concluded, we submit correctly, that it was just not economically viable, particularly given the way the city has defended this case, for any one of those class members to initiate their own suit and prosecute their own suit. And for that reason, class treatment was the superior, indeed we would say the only, economically viable method. And there was no evidence presented by the city of any difficulties in managing a class of this size. And as I said, the evidence on the merits, to the extent we want to discuss that, did show that the fees were spent for a purpose that is not permitted under the Constitution. And consequently, we submit all of the issues, or the elements rather, of Rule 1.22a were satisfied. There is a justiciable controversy between Ms. Conlon and the city. It's continuing. The class members of Ms. Conlon have the same legal interest. They assert the same legal challenge. If she proves her claim that the fees are unlawful, she will necessarily prove the claims of all class members. The city has acted in a way that is generally applicable to all class members. They've applied the statute or the ordinance uniformly. And as I said earlier, the trial court concluded then that the class treatment was the superior way to handle this dispute, and that the common issue, that is the legality of the fees, was the predominant issue. It's the dispositive issue. So it was predominant. So we submit, if we confine ourselves, as was done in Higgins, to the class certification issues, putting aside what they contend they will ultimately be able to show on the merits of their affirmative defense, the trial court was eminently correct in certifying this class. I think I've answered all the points that you raised, Judge Rowe. Let me just check my notes here to make sure. Judge Van Nortwick, I did want to respond to one point you raised, which is why can't equitable estoppel apply on a class basis? We believe it certainly can. Particularly on this record, you have an ordinance that's on its face misleading. You have an internal communication in the record showing that they knew that the methodology didn't comply with standard impact fee analyses. They made the conscious decision not to put the methodology in the ordinance in order to avoid scrutiny of the ordinance. And there's no evidence in the record that anybody outside of those in control of city government ever knew that until after this
What
case.
about reliance?
Well, if you look at the Council Brothers case and the SAP case, those cases show that if you're asserting equitable estoppel against the state, you may simply assert and travel on an omission or misrepresentation and failure to assert the claim timely. If you look at those cases, they seem to relax, the Supreme Court did in SAP anyway, that particular element of the reliance doctrine. But again, that goes to the merits of their affirmative defense. So I believe I've answered the questions posed by all of you. If I haven't, let me just... Oh, and the final point I guess counsel made in regard to the Baptist Hospital case, which I believe you were on that panel as well, Judge Padovano, the difference there is the defense came forward and actually had presented evidence that the plaintiff had not been damaged by the lien claim. That was a lien claim challenge. There was actual evidence in the record that the plaintiff had not, in fact, been damaged. And for that reason, he did not have standing, and that's quite different than what we have here. So we would ask you to affirm the order. It was not arbitrary, fanciful. A reasonable person would do what the trial court did on this record. And so if there are no other questions from the panel, I'll stand on our papers for the